and welcome. This is Background Screening Tips and Tech with me, Tim Santoni. And today we're excited to have an awesome guest on our show, Montserrat Miller, partner at Arnall Golden Gregory, is joining the show. Thank you so much for joining the show and offering to be interviewed on the show today. Thanks, Montserrat.
Absolutely. I'm happy to be here.
Awesome. But before we get started, I want to give a little bit of an introduction just so that viewers that are not familiar with Montserrat, she's been a really valuable asset to the background screening world. She is the co-chair of the background screening team at Arnall Golden Gregory. She's also certified by the International Association of Privacy Professionals, the IAPP, as a certified information privacy professional, both in the United States and the European Union. I also want to point out that Arnold Golden Gregory is recognized as a member in good standing with the PBSA, or the Professional Background Screeners of America, or Association of America. And she actually recently just spoke to the industry at the Tazworks user group on a legal panel discussing many of the pressing topics, and it really is a valuable asset to the background screening industry. In fact, Montserrat and her team and her partner, Kevin, helped me when we set up our background screening platform on Tazworks with regard to our user agreements and our privacy policy. And again, I really encourage you to connect with Montserrat. We'll definitely connect up all of her information in the show notes below. Before we get going, Montserrat, maybe just give us a sense of professionally, what is it you enjoy doing most, and maybe something personal so we can connect with you a little bit deeper.
Sure. Well, I had not thought about the personal question quite yet, but in terms of professional, so I've been at Arnold Golden Gregory, AGG, for the past 11 years, and I view myself as a data privacy attorney with a specialization, if you will, in the Fair Credit Reporting Act. And as you mentioned, I'm co-chair of the background screening industry team here at the firm. So I've been engaged and involved in the industry now for several years. If I were to count, maybe it would be about 15 years. So certainly something I enjoy doing is helping CRAs, end users, and just vendors within the background screening ecosystem to comply with the different legal requirements, as well as review contracts and talk about or advise on other issues related to background screening. So that is me professionally in a nutshell. In terms of something personal, the only thing that for whatever reason jumps out at me right now is I do enjoy backcountry hiking, although I did hike the Grand Canyon, and we were I'm so traumatized by it that I can't remember now if we were the north or the south rim, whichever one is more difficult. And we went from the top down to the Colorado River, and it was not for the faint of heart with respect to heights. And I am scared of heights. And so if anybody has done that backcountry hike, I think I get some kudos for doing it, notwithstanding my extreme fear of heights.
That's pretty awesome. Yeah, that's not one for the faint of heart if you're afraid of heights. I will point out that this podcast should not be construed as legal advice. We advise you to consult with an HR professional or counsel before making decisions. This is informational purposes, and again, should not be construed as legal advice. All right, well, let's jump into the show here a little bit. I guess there is a recent decision that came down that impacts a lot of people in the background screening industry, namely CRAs as well as employers. That's the Arnold v. DMG Mori case, and it has to do with disclosures and authorizations. So maybe Montserrat, maybe you can break down from a practical sense what that means for background screeners and for employers that are facing compliance requirements around the authorizations, forms, templates, and the kind of the process of collecting that information.
Sure. And thanks, Tim, for mentioning the disclaimer that this is not legal advice. I just want to reinforce it that it's not legal advice. It's just a discussion that we are having. As far as Arnold v. DMG Mori, this follows a string of cases from the Ninth Circuit out in California, and it's about providing guidance, if you will, with respect to the disclosure and authorization. And so that's something that employers have been looking, I think, for that guidance, and certainly consumer reporting agencies or background screening companies have been looking for that guidance. And in the vacuum of FTC or CFPB not providing a template, if you will, we have to rely on court cases. And so DMG Mori is one of those cases that came out earlier this year and just shed a little bit more guidance on what should be, or what actually, better said, what cannot be in the disclosure and authorization. So let me just take a step back. an employer has an obligation under the Fair Credit Reporting Act to provide the applicant, the job applicant, with a disclosure and to capture their consent. And that disclosure, per the FCRA, is such that it has to be clear and conspicuous and in a standalone document. And once provided to the individual, then the job applicant has to authorize in writing that they agree to a background check. And so years back, Tim, as you probably remember, disclosure and authorizations were much more verbose and included a lot of language that has now become extraneous. And so, or at least considered extraneous by the courts. And what happens is when an employer has extraneous language in a disclosure and authorization, it can lead to a claim that they violated the Fair Credit Reporting Act, which can then lead to compliance violations, if you will, under the law. What DMG Mori did is just further carve out what cannot be in a disclosure and authorization. And so this is really something for employers and also for CRAs who provide templates. But practically speaking, where I come down on this is that what the court said is that you can't combine the language from an investigative consumer report and a consumer report in the same disclosure. And the reason for that is that the court faults certain language that was in the disclosure and authorization. And that was actually me turning the case. It's not very long. It's only a few pages long, but basically the disclosure at issue had language that said the right upon written request made within a reasonable time to request whether a consumer report has been run about you and to request a copy of your report. That was the extraneous language that was included in the alleged faulty disclosure that DMG Mori provided. And the court said that's not acceptable. And so when you look at that language, part of that language is found in the section in the Fair Credit Reporting Act that relates to investigative consumer reports, which are different than consumer reports. What was so basically any such language in a disclosure would be considered extraneous and thereby violate the Fair Credit Reporting Act. What was even worse about DMG Mori is that the court said that that language and that behavior was a willful violation. And when you get a willful violation as opposed to a negligent violation under the FCRA, it can lead to punitive damages as well as to up to $1,000 per violation. So certainly significant in that, one, the decision said, here's additional language that the courts will find violates the FCRA as being extraneous. And two, we're going to make it a willful violation.
Yikes. That could be the calling card for a lot of plaintiffs' counsel to file similar cases if they know that they can get those kind of damages and potentially attorney's fees and other, just it escalates things. So, wow. Right. So, in essence, if you're doing the background screening, whether you're an employer or you're a CRA, you need to update your authorization disclosures, or at least have them reviewed by counsel to make sure that they at least are not extraneous and don't violate this particular case.
Right. And Tim, here are some practical takeaways from the string of cases that have come from the Ninth Circuit. One is, you make a great point. Review your forms, whether you're the employer or whether they're templates that you provide as a CRA to your end user clients. Do that at least annually, and certainly after a major decision like DMG Mori. So that's one. Number two is, it's okay, because there have been other cases that have said it's okay to include the disclosure and authorization forms with the employment forms, but make sure that they're separate. Another takeaway is, we know from prior cases that certain language it's going to be considered extraneous if you have any type of release of liability or waiver of claims language. If you have any language in your disclosure about at-will employment, don't see that as much, but you used to see that. If you've combined the disclosure with the state disclosures, that's a big one too. And so what does that mean practically? It means that you need a few documents when you're providing that disclosure. And one of them is just straight up the FCRA disclosure. Separate is the authorization. And in the authorization, you can include the evergreen consent language, but make sure that the disclosure and the authorization are on separate pages. And really, Tim, I generally recommend, and no one quote my language exactly, because this is not legal advice, but I generally keep disclosures to companies seeking a consumer report on you for employment purposes, which may include, hiring, retention, reassignment, promotion, and the report may include criminal history and certain other types of checks. That's almost as basic as I keep it. And then separately, you would have the authorization, and that's just to comply with the FCRA. We won't get into California and ICRA at this time because that's another form.
Gotcha. Well, that's great. That's great practical guidance for something that can be very, very complicated. Moving on, I think that one thing that we wanted to hit on today is this idea that, there's been a recent California court case as well as that's on appeal, and a similar case in Michigan a change that's really telling the courts that they cannot provide full dates of birth and driver's license numbers on their indices, which means that from a CRA perspective, that we can't search by full identifiers, a full name and date of birth, nor it may be restrictive in reviewing cases where that information is available. And I get it. There was a case out of Riverside County that said this information shouldn't be made available, which I get it from a privacy perspective. But the challenge is, practically speaking, as a CRA, the goal is to verify records found and make sure that the person that you're searching for, the records pertain to them or exclude them, and to be diligent in those efforts. And under the FCRA's reasonable diligence is the kind of the term. I know that you and Kevin recently launched a podcast, AGG Talks Background Screening. And in the first episode, you guys hit on this, but give us your high level takeaways from your perspective. I know this is kind of an evolving topic as it's pretty recent, but give us your takeaways.
Sure. And Tim, remind me to circle back with me about the settlement hearing for DMG Mori, because you'll get a sense of the cost of a violation of the FCRA. And so, you have Michigan, you have California. It's true. My colleague Kevin Coy and I did do a podcast on this. So my high level take from this is it's an evolving situation. I really do hope that the efforts of PBSA, the Professional Background Screening Association, and CDIA both will help to mitigate some of the consequences and fallout from both of these situations, if you will. So, and certainly they have been pushing, as have other stakeholders in this area. But you have California that it's being driven by litigation, where private litigants have brought a claim and have alleged that there was a violation of the California court rules with respect to the use of DOB and driver's license. And then you have Michigan, which was driven by the Michigan Supreme Court and was more in the form of rulemaking, if you will, by the Michigan courts, which had also redacted DOB. And, both of them seek to help consumers in different ways. I think in California, it's more driven towards allowing those ex-offenders to re-enter, and the idea of being through employment. And then in Michigan, the idea was to protect personally identifiable information, and this would be such information. And I think both of those really are misguided, because for a consumer reporting agency and then for the employers that they service, the idea is that you want reports that are accurate. And in order for accurate reports to be provided, you need some key identifiers. And one such key identifier is date of birth, and particularly full date of birth. And so when you have the Fair Credit Reporting Act that controls, from a compliance perspective, what consumer reporting agencies or background screening companies have to do, they have to have reasonable procedures in place to ensure maximum possible accuracy. If the courts, be it through litigation or through rulemaking, take away a key identifier, to me, that doesn't serve anyone, because now you have to turn to other identifiers. And we know, Tim, that SSNs are being redacted. And in California, they're also redacting perhaps driver's license numbers. Well, those are all key identifiers. And so you're actually driving towards the courts, and others are driving towards a place where it's almost a less accurate report than a more accurate report. And so I think practically as a background screening company, you're left with few options, really. And because you can do name, and we'll talk about that in a second, a name only search. But if ideally you want name, date of birth, or name, social security number, at least 2 identifiers. And if you have a common name, you want 3 identifiers. So to me, I haven't come up with a good solution yet for background screeners, because it's almost like your legs have been cut out from underneath you in terms of trying to provide an accurate report by redacting date of birth.
Yeah, it's a tough one. And I think that there's been some guidance in theory that there's other pointer data that could be accessed to try and verify the record. However, social media, arrest records, other things that are not necessarily verified should not necessarily be introduced, because it's reasonable diligence to go that route. But like you say, it begs the question, which is the courts are really forcing us to be, as background screeners, less accurate. So do you report the record based on that and then wait for them to question the results and reinvestigate because the time and cost associated with doing it is too difficult? Or do you go the extra mile and you spend the extra time and the cost to try and dig through and see if there's information in the records or the indices or the dockets to help, as an example, you have LA County, which is one of the largest counties in the country, where you have very common names. There's a lot of people that with the name Tom Smith that were born in, October of 1980. And so, you're actually, the courts are putting a burden on themselves, which is there's more and more records to be searched for. It's going to take longer to go through the data, which is going to take more time and cost more money. And in essence, it's going to cause a slowdown. And we've talked about a little bit internally, which is in this time where people are really pressing to get people into the workforce, slowing down the background screening process and increasing the cost is going to create a risk or a liability situation, because we're finding that more and more employers are either proceeding without the background check, hiring in spite of what's found, or not running searches in those areas because they can't afford, from a time and cost perspective, to move forward. And so I also have another comment on this because I think that it's interesting. A lot of background checks are requirements for a master service agreement or in order to work with the state or a federal government agency. In order to work with them, you must comply with these different things. And so the courts are cutting the legs out from underneath people that need this information in order to comply with their contracts or agreements, which are government based. And so that to me is it's just a very interesting dynamic.
Yeah, it is. And I would say, from the perspective of a background screener, if you're left only with the name, I would just caution any background screener who reports a name only search. That's one identifier, and it's just not putting you in a place where I think you would have reasonable procedures to ensure maximum possible accuracy. So again, I'm still thinking through what the solutions might be, because like you said, Tim, you might look at other information in the court records, but name and date of birth just happens to be a key. And, there's pressure from the federal agencies with respect to particularly the common names that you mentioned, and, CFPB, the Consumer Financial Protection Bureau. There was an enforcement action against a background screener where that was an issue. And really there was a push towards having 3 identifiers for individuals with common names like, Jane Smith, having that 3rd identifier. So taking this away is not at all helpful if you want to be in a place where you're producing accurate reports. And I don't think the solution is not running background checks, but I hear your point that employers' turnaround time is generally 48 to 72 hours. So 2 to 3 weeks and 1 month where you start to get into staleness is not the solution. So, I really hope that PBSA and CDIA's efforts with respect to, in California, trying to educate the courts that they'll avail in the long run. Gotcha. And that is an open question, since they did file an amicus letter, if you will, to the court.
Yeah, and despite the fact that this case in California is on appeal, we've seen Los Angeles County, Kern County, Fresno, and other counties are already removing and restricting this information. I guess in a bigger picture, I guess the one thought that comes to mind is that background screeners and CRAs being one aspect of those that really rely on these records from the courts. But at a higher level, state, local, and federal law enforcement also need this information. And so my concern is that they access the same records that we do, despite what a lot of people think. And so why aren't there layers that allow people that should have access to it, the proper access, background screeners being one of them for permissible reasons and have with authorization and so forth, but also law enforcement. So if you have law enforcement in Florida that needs to access records on a potential criminal in California, you're slowing down their ability to verify information and records on that potential person that they're investigating or potentially arresting. So again, I'll get off my soapbox and move on. The third thing I want to talk about is the new Illinois law really restricting the use of criminal history. And they talk about an interactive assessment, which again is very long and lengthy. And it's similar to, in my opinion, the ban the box assessment that a lot of employers, especially in California, have to adopt, which is a 3-part, which is, severity of the crime, time since the crime occurred, the impact on the job, and kind of rehabilitation efforts. And so I know that you guys, the Arnall Golden Gregory legal update, you guys wrote a really great piece on this, but maybe at a high level, tell us a little bit about the practical stuff that you'd recommend on that, Montserrat.
Sure. So this dates back, these individualized assessments, although in Illinois, they're calling it an interactive assessment. But these, in my opinion, date back to EEOC guidance on the use of criminal history, and even further back to the Green case, which was from the 1970s, that talked about different items to consider in order for the use to not be a discriminatory practice, and make sure that it's job related and consistent with business necessity. And so there were sort of 3 core factors: the nature and gravity of the offense, time that had elapsed since the offense occurred, and the nature of the job that was held. And so in Illinois, what they are doing with respect to the use of conviction records, and this is a requirement, compliance requirement on employers, not CRAs, but on employers. And so with the interactive assessment, what they're requiring is that you look at certain things, such as length of time since the conviction, the number of convictions, the nature and severity of the conviction, and the facts and circumstances around that conviction, and some other factors. And what you're trying to do is to tie it back to whether the use of that conviction record, whether there's a substantial relationship that exists between the conviction and the position, or whether there is an unreasonable risk to property or person. So that's what you are trying to do. Interestingly, Illinois didn't produce, that I've seen yet, any type of a template to help. However, New York City, which has a similar law, the Fair Chance Act, does have a template, a notice that employers can use. So I think one practical tip that I would give employers listening today is to look at New York City's Fair Chance Act notice, because it does walk you as an employer through the individualized assessment process, and forces you to fill in certain boxes, if you will, but just it facilitates the discussion with the individual. But to be clear, in Illinois, my recommendation would be that if you're using conviction history on an applicant, and it's, after conditional offer of employment, you have to walk through this assessment, and you do it at the same time that it runs parallel with the adverse action process under the FCRA. And so I think the way that it would play out is that employer requests background check comes back. Check has information that's adverse to the job applicant, and specifically in Illinois, conviction history. And then you would have to engage in this interactive assessment, whether in paper or with the individual, but I would say capture it in writing, and then go through the steps and try to determine how does the conviction tie to the job? And is there a relationship there? So I know this is a very canned, common one, but daycare center and individual has a conviction for child endangerment or abuse. I mean, that ties directly. But if it's a daycare center and individual has a conviction for something unrelated, maybe they didn't have their deer hunting license. Well, those don't really relate to the job. And so make sure there's a relationship between the conviction and the job, and then make sure that you determine, is there some type of an unreasonable risk to individuals? I mean, you can do both of those and to be on stronger footing, but you actually have to go through this process with individuals. So realize, as an employer, if you're going to use conviction history, that you are setting yourself up for this, and you just have to have certain procedures in place.
Gotcha. Great. And we'll definitely link up the article that Montserrat and Kevin published there as well. All right. So stick around to the end, because we are going to talk about DMG Mori and what the settlement costs look like. But before we go, Montserrat is a data privacy expert. And so one question that I wanted to pose to her is the GDPR and how the impact of that. It's a very complicated situation as it relates to compliance. But specifically, I guess what I'm curious to hear about is US-based CRAs, small and medium-sized growing CRA. They take on clients that have operations or are hiring globally, especially in kind of a global economy moving into. What are some considerations? What are some things they need to be thinking about as it relates to collecting data from applicants that are specifically in GDPR or European Union, governed countries?
Right. So number one is you just have to be familiar with the General Data Protection Regulation. That's number one. And I think number two, realize that you can operate in those countries, and I know that more background screeners are looking to operate in Europe. But if you're dealing with data subjects who are in the EU, and then it goes through all shades of gray from there, but you have to understand that the collection of data, personal data, is generally restricted. And you have to have what would be almost the equivalent of a permissible purpose in order to collect and use the data that the Europeans call process the data. So that's number one. You need to have a reason, a lawful reason or basis in order to even collect that data. And number two is, if you are looking to transfer that personal data to the United States, you need to have a lawful mechanism to transfer that data to the United States. It used to be that CRAs would do that under Privacy Shield, but Privacy Shield was ruled invalid. And so now we turn to standard contractual clauses, which were updated this year, but you need to have those in place with organizations that you are dealing with, where you're transferring the data of individuals in the EU for processing in the United States. So those are the three big takeaways. One, be familiar with the GDPR. Two, realize you need a lawful basis to process the data. And three, that you need a lawful basis to transfer the data to the United States from the EU. All of which can be found under GDPR if done properly, but it is not something that you would rely on exclusively on consent of the individual.
So when you say a permissible use, would a background check with authorization for the purposes of employment be a permissible use?
It's not. Yes and no. Yes, in the sense that you would need the consent, but no, in the sense that under the GDPR, that wouldn't be the basis alone. It would be for legitimate purposes that you're processing it. And the reason that you cannot rely on consent alone in the EU is that the Europeans believe that there's an imbalance of power in an employment relationship, meaning that as a job applicant, you're always going to say yes because you want the job. You're always going to consent to what is being asked of you.
Got it.
So there has to be another basis to process the data. Having said all of that, consent does go a long way with respect to authorizing an action. And if we're dealing with somebody in the United States, under FCRA, you absolutely need consent.
Gotcha.
Your background check.
Got it. And my guess is that if somebody needed to update their policies and procedures and those documents, that you or someone at your firm would be able to assist in making sure or reviewing those so that they are in place and are compliant.
Absolutely. We'd be happy to help.
Awesome. All right. Well, Montserrat, before we let you go, we're hanging on the edge of our seats here. DMG Mori, because it was willful, my guess is that the damages were significant, the penalties. So tell us from a dollars and cents perspective, what that case cost in terms of settlement.
Sure. So I think be ready to hear that news in the next few days, because they actually have the settlement hearing is on the 26th of August. And right now I was just looking at the court documents. So the total amount is $825,000. Interestingly, $450,000 of it goes to attorney's fees, and $375,000 is going to the class members, which breaks down to about $462 per class member. And so, but the total does, if the court approves, the total to DMG Mori at this time appears that it's going to be around $825,000 for really what are essentially, it's not as if DMG Mori didn't provide the disclosure and try to capture consent.
Right.
It's a technical paperwork violation.
Yeah. Well, that's interesting. We'll stay tuned for the final settlement on that, and definitely connect with Montserrat to stay up to date on any legal updates, and obviously connect with her if you're interested in having any of your documents reviewed, which based on her guidance annual is good. And when there's landmark cases that come down, there's 2 or 3 that we've even alluded to on this short little podcast. So definitely reach out, and definitely tune into AGG Talks Background Screening with Montserrat Miller and Kevin Coy. It's their new podcast, which was hosted on all the major platforms, as well as you can access it on their website. Montserrat, before we let you go, anything that you want to share with us or direct us to in terms of upcoming events, or anything that you want to, share with the listeners?
I appreciate our time and our discussion, and looking forward to continuing this discussion in future podcasts.
Sounds great. Well, thanks so much for tuning in to Background Screening Tips in Tech. Again, you can download us wherever you get your podcast, and stay tuned for future episodes. On the next episode, we'll look to be talking about social media screening, and we plan to bring on one of the leading partners in the field. So thanks so much for tuning in, and we'll talk soon. Thanks.